Respected Vice Chancellor of Royal Global University, Mr. Pansari in absentia, Mr. Ankur, the Executive Vice President, Mr. Ajit Borthakur, former Judge, Guwahati High Court, Mr. Indranil Chaudhary, Advocate General, Arunachal Pradesh, learned senior advocates, Professor Bhuban Barua, the Dean of the Law Department, learned faculty members, distinguished guests, and my dear students. I'm sorry I'm late by 10 minutes. Actually, I was held up in the National Law University. I'm a mentor there. So they have started a lecture series. So today, Mr. Arvind Dattar, he has come and he is delivering the lecture. And a lawyer of the eminence of Arvind Dattar. So I thought I would have to be there. So I was there for some time. Because of that, I got delayed. I'm so sorry for that delay. And it is indeed a very nice feeling to be back here in the Royal Global University. I think first time I came when I was a judge here. I think the Moot Court Hall was inaugurated at that point of time. And the last time I came was about 2 years back. This auditorium was not there. So I can see a lot of changes and improvements in the university. Within a short span of time, the university has achieved considerable success. I must congratulate the management and the faculty of the university for the commendable achievements within such a short span of time. And we can expect much more laurels, many more laurels in the coming months and years. Friends, the topic of today's interaction is from constitution to courtroom, opportunities for the next generation of law graduates. Now, as students of law, I consider myself to be a student of law. Our Constitution of India is our ground norm. It's the ground norm. It is the basic law of the country. And therefore, it is necessary that each one of us must know about the Constitution. The Constituent Assembly, led by Bharat Ratna, Dr. Babasaheb Bhimrao Ambedkar, they have gifted us a most vibrant document, the Constitution of India. The courts, judges, and lawyers alike are all guided by the vision of our Constitution. But why only judges and lawyers? It is the fundamental duty of every citizen of India, or if I may say so, every person living in India, to abide by the Constitution and to respect its ideals. Article 51, capital A, is the chapter on fundamental duties. It was brought in by way of the 42nd Amendment in 1976. And one of the foremost fundamental duties of a citizen or a person living in India is to abide and respect the Constitution of India. I go to very many educational institutions. I go to many universities. In fact, some of my colleagues have jokingly named me Bhuyan the Professor. So I love going to the universities. There are two reasons behind this, why I go to the universities. First and foremost is that in the universities you come across young people, vibrant minds, minds which are not fettered, or minds which are yet to be polluted. They have their own ideas, and very good ideas. And they are not influenced by the corrupt ideals which are outside the campuses. So therefore, it is always a good feeling to be amidst young people. You carry with you new ideas. When you meet young people, things that you take for granted you may think that I know this much. After each meeting with young students, I have always felt that I take back something new after meeting the students. And secondly, the second reason, and it's more fundamental, is that one of my neighbors, my very eminent neighbor, he once told me that I always like to hang around with young people because that's an antidote for aging. So if you want to stay young, stay with young people. So this is one more reason why I like to go to the universities and meet my young friends. Now, coming to this constitution, wherever I go, I ask my students, please tell me which article of the Constitution of India you find, or according to you, is the most important. Some would say Article 19, some would say Article 19, certainly you know the fundamental freedoms. Some would say Article 21, the right to life and liberty. Some would say the preamble to the Constitution of India. I agree, each one of the articles is very, very important. But according to me, the most important of all the articles is Article 14. It is Article 14 captures the essence of equality. Equality between men and equality between men and women. That is the cornerstone of our Constitution. In fact, if you look at the previous speeches of Dr. Ambedkar, Dr. Ambedkar, through his various speeches and writings, had repudiated the caste system. He had said that this is immoral, this is socially repugnant, and economically unviable. So then he was asked, since you have repudiated the caste system, what kind of a society you aspire for? He said, I look for a society which is based on the ideals of equality, which is based on the ideals of fraternity, which is based on the ideals of justice. Equality, fraternity, justice, these are the foundational principles, the guiding principles of our republic. Ambedkar's thought process finds enough way into this, our Constitution. The preamble is a window to the Constitution. In fact, there was at one point of time, there was a debate whether the preamble is a part of the Constitution or not. In Keshavananda Bharati, the bench said, the 13-judge bench said that preamble is as much a part of the Constitution of India as any of the articles therein. So there is a scholar, Granville Austin. He has written extensively about the Constitution of India. He is an American scholar. He has written extensively about the Indian Constitution. And he's been a critic too. He has described the Constitution of India as a social document, the primary objective of which is to build a democratic and equitable society. I would go a step further. I would say our Constitution is indeed a transformative document. It's a scientific transformative document. It has transposed a deeply feudal, highly unequal, fractured society practicing graded inequality into a modern, forward-looking society. One that upholds justice, equality, fraternity, and dignity for all. So my young students, friends, I urge upon you to kindly read the preamble and what it says. In fact, I have kept the preamble on my table. It was gifted to me by one of my colleagues, and I have carried forward and I have kept it on my table. Every morning you look at it. Every time you read the preamble, you will find a new meaning to it. You will find the guiding light to how the law and the society should work for advancement of the cause of humanity. Friends, when the COVID pandemic broke out, this is in 2020, March, I was then a judge in the Bombay High Court. We had a lot of spare time with us. The courts were also closed for the initial period, whereafter we started having virtual courts. So, one student ambassador, she said, she reached out to me, she said, I am from SCC Online, can I have an interaction with you? Normally, judges should not give interviews. I have the view that serving judges should avoid interviews, not to speak of holding press conferences. It is unacceptable. But since SCC Online is a law-related, law magazine, law reports, so I said yes. So in the course of the interaction, she asked me very many questions. One question she asked me, sir, do you find any executive or political interference or influence in the judiciary? It was a very loaded question actually. So I said, I remember to have told her that I can't speak for others. But speaking for myself, I have never faced any political interference or executive interference. It has not influenced any of my decisions, be it administrative or judicial. Then I went on to say that our judiciary has been built literally brick by brick over the years, even prior to the Constitution also, by great men and women. They have contributed immensely to the growth of the institution. And for the last 75, 76 years since the Constitution is in place, by and large, no institution can be perfect. By and large, the Indian judiciary has performed well. There can be aberrations. It is bound to happen. Such a big institution. We have more than 15,000 trial judges in the district courts, more than 1,000 judges in the high courts, and 34 judges in the Supreme Court. It can't speak in unison. It's better not to speak in unison. So therefore, there are aberrations. Aberrations are bound to happen here and there. But notwithstanding that, by and large, Indian judiciary has performed well, commendably. One such, so therefore it is very essential that as students of law, we should all know about the lives of this great man. One such great man was undoubtedly Nani Palkhiwala, the greatest lawyer of all times. I'll just give a brief recap of the life of Nani Palkhiwala before I move on to the next segment of our topic. He did not come from a very rich background, very humble Parsi background he came from in Bombay. His father had a very mediocre, small-scale laundry unit in what is Tardeo now in Mumbai. From there. And during his initial days, he suffered from stammering. His brother used to tell, in fact, Arvind Dattar he has written a book along with Soli Sarabji about the life and law of Nani Palkhiwala, titled The Courtroom Genius. And he has said that during his childhood, Palkhiwala could hardly speak a sentence, complete a sentence because of his stammering. But so hardworking he was, so persevering he was, that he used to deliberately go and join the extempore quiz competition, the debating contest, trying to overcome his speech impediment. He used to put almonds beneath his tongue to overcome his stammering. He joined Bombay University. His initial inclination was towards English literature. He wanted to be a professor of English literature. In the competition, it happened that he was not selected. Perhaps the interview board was also influenced by the fact that he had these bouts of stammering. So therefore, he turned to law. He joined the iconic Government Law College, Mumbai. It's 1850 vintage. In that law college, he studied law. Then he was fascinated. He wanted to be a tax lawyer. So he thought that if you want to be a tax lawyer, and it's true for everybody, you must know a little bit of accountancy. But he did not have the money to join a formal accountancy course. So, as you know, the Parsi society is a very close-knit society, and they help each other out. So one gentleman, he said, I will teach you after you complete your classes, law classes, I will teach you about cost accountancy. So this is how Palkiwala evolved. And after graduating from the Government Law College, he joined the chambers of Sir Jamshedji Kanga. I am talking about, this is late 30s, this late 30s, early 40s in Mumbai. Sir Kanga was one of the outstanding lawyers, one of the very busy lawyers of Bombay at that point of time. And Bombay, as you know, space is a crunch. So Kanga had a table, a medium-sized table. The juniors had small tables. Palkiwala's junior at that point of time was Fali Nariman, the same chamber. And over a period of time, his clientele became so big, Palkiwala's clientele became so big, that he had a Hilton vehicle. His conferences, he used to go and have the conferences in this vehicle. So at that time, under the Income Tax Act 22, we had the Income Tax Tribunal, Appellate Tribunal started functioning. So he started appearing there, and Bombay High Court then come to the Supreme Court. And he could overcome his disability of stammering, and in due course of time became one of the outstanding orators, speakers in the legal field. Now, not only this was a physical disability that he faced. He had faced another obstacle in his very early life. In 1946, when he started practice income tax, he found that there were very few good books on income tax. Hardly any book on income tax. One of the book was Sampath Iyengar's, income tax scholar from Madras. He had a book, Sampath Iyengar's Law of Income Tax. But other than that, there were very few books. So Palkiwala thought that why not let me try and write a book on income tax. He took it up with his senior. The senior said, it's a good idea, please go ahead. So they commenced writing from 46 and 49, the first volume of, and he named this book as Kanga and Palkiwala's The Law and Practice of Income Tax. This is still now one of the finest commentaries on income tax, along with Sampath Iyengar. Now, in 1951, Sampath Iyengar had come to Calcutta for some conference. In one of the bookshops, he found this book, Kanga and Palkiwala's Law and Practice of Income Tax. And according to him, there were several paragraphs in this book which were verbatim the same as he had written in his book. So he instituted a suit. Initially he issued legal notice, thereafter he instituted a suit in the Madras High Court. Unlike Guwahati High Court, the chartered high courts, that includes Madras High Court, they have original jurisdiction. So he instituted a suit for infringement of copyright and claimed damages. Palkiwala was a defendant then. And he was subjected to severe extensive cross-examination. Sampath Iyengar alleged that Palkiwala had transposed from the body to the footnote and from the footnote to the body several passages from his book. Ultimately, the judge of Madras High Court, he dismissed the suit. He found that there were no instances of copying, and he observed that perhaps Sampath Iyengar was overtaken by emotion when he instituted this suit against Palkhiwala. So that was this unfortunate incident was a great setback for lesser mortals. It could have spelled the end of our professional career, but then this only spurred Palkhiwala to newer and newer heights. So then Palkhiwala, from then onwards, one case after the other, he established himself as India's premier tax lawyers. In fact, Mr. Dattar was saying that in Madras High Court they have brought out a small booklet that what are the subjects that you have to deal with when you deal with income tax law. The Hindu law to a great extent has developed thanks to the interpretation given in the Income Tax Act. For example, the taxing unit, which we call the Hindu undivided family, the law of partnership, the law of the company, and now you have got the insolvency and bankruptcy code. So, by that time, Palkhiwala became a very, very busy lawyer, and as per the and as per the legend, as it goes, his conferences became legendary. He had no time, so therefore from his house in Nariman Point to the airport, it took about 40-50 minutes time. He used to take along with him one client, discuss the matter with him, one client on the flight to Delhi, one client in during the breakfast. This much of, but the key to Palkhiwala's success is the enormous amount of hard work that he put in. I remember one of the wives of a very senior judge of the Guwahati High Court once telling that in this profession, luck, chance and opportunity are very important. The trilogy of luck, chance and opportunity is very important. But as a lawyer, certainly you will have your slices of luck, opportunities will come your way, but you must be fully prepared to grab the opportunity as and when it comes and not let it go. Opportunities and luck, they don't come often. They come once in a while, and you must be fully prepared to grab that opportunity. Palkhiwala was that. He had put in enormous hours of effort to separate the grain from the chaff, so to say. But friends, it will be wrong to confine Palkhiwala, the genius in Palkhiwala, only to income tax law. As I said, income tax law is a window to various other branches of law, including constitutional law. And it is in the field of constitutional law that Palkhiwala's contribution would remain unparalleled and outstanding. Number of judges, number of judgments. I will not name all this. I'll name just 4 of the judgments which Palkhiwala had argued on behalf of the petitioner. The first, of course, is those who are students of constitutional law, you will know the 11-judge bench of Goloknath versus State of Punjab. It all started from the agrarian laws. Ultimately, this all boiled down to the power of the parliament to amend the constitution, Article 368. Those who are students, again I am saying those who are students of constitutional law, you will know, Article 368 deals with amendment of the Constitution of India. Various amendments were brought in by the parliament bringing in agrarian laws, reforms, particularly from the state of Punjab. Till this point of time, whether it is Sankari Prasad in other cases, Supreme Court held a view that this power of amendment under Article 368, the power of the Parliament is plenary. By exercise of this power, Parliament can amend any provision of the Constitution of India. There was no limitation. In Goloknath, it was a fractured verdict. The majority, 6-5, the majority held that you can amend the Constitution. There is no embargo on it. But the fundamental rights in Part 3 of the Constitution of India, by virtue of its very nature, cannot be subjected to the process of amendment. So this was a completely U-turn from all the judgments, Sajjan Singh, then earlier Sankari Prasad. So Supreme Court took a virtual U-turn. There were other issues also, like the doctrine of prospective overruling. We are not concerned with that. This case was argued by Palkhiwala. The next important case in 1969, 14 major private banks were nationalized by the government of India. The Prime Minister took a policy decision to nationalize 14 major banks of India. Dattar says that this was done on a Saturday. Those who practice law, they know that many impugned orders are passed on a Saturday so that there's a Sunday, people can, the effect can take place thereafter. The impugned order can have its effect. The petitioners, they approached Palkhiwala. I am told the writ petition, this is the 32 petition, was drafted in a span of 2.5 hours. Palkhiwala flew down from Bombay to Delhi, and it was filed on Monday and it was moved on Tuesday. And they got a partial stay that the chairman and the managing directors of this private bank should not be removed. Many points were argued, but the important for us, students of law, is the point regarding the interaction or the intertwining of the fundamental rights. If you recall, in 1950, we have that famous case of A.K. Gopalan versus State of Madras. A.K. Gopalan was a communist leader. At that point of time, the Communist Party was proscribed. And Gopalan and Kerala, these were all part of the Madras presidency. Gopalan was arrested under the Preventive Detention Act. This was challenged under 32, initially Madras High Court, then it came as ultimately a fresh petition was filed in the Supreme Court. The majority, the argument was that this was violative of 14, 19, 21. It was arbitrary. It had infringed upon the right of Gopalan to freely express his views and his right of movement, curtailed his right of movement, and also that this preventive detention was without the due procedure followed by law. If you recollect, the Constituent Assembly had specifically rejected the American Due Process Clause, and they said that in India we will not have that. So following that, the majority held that principles of natural justice are too vague. We can't read a constitutional provision on the precepts of vague principles. They said there is a preventive detention law, and this law was followed by the authority while carrying out the preventive detention of Gopalan. So therefore, requirement of Article 21 was complied with. And that 14, 19, 21 are different silos. They can't be mixed up. In 1970, in this R.C. Cooper case, R.C. Cooper, Rustam Cooper had challenged the bank nationalization of 14 private banks. In this case, Supreme Court, 11 judges, so again another 11 judges of the Supreme Court said that no, 14, 19, 21, in fact, all articles comprising Part 3 of the Constitution of India are interlinked. An executive action or a legislation can be challenged on all grounds, as arbitrary under 14, that it violates the freedoms under 19, that it is without the due procedure under 21, so on and so forth. So this was the principle developed. This was again argued by Palkhiwala. In 1947, when India became independent, there were a lot of princely states. They were hesitant to join the Indian Union. The government of India gave them option. If you join the Indian Union, you will be given some financial packages, some financial privileges. These privileges were known as privy purse. So these princely states were given privy purse. In 70, the government decided to withdraw these privy purses. Madhav Rao Scindia, the father of Jyotiraditya Scindia, he filed a writ petition in the Supreme Court challenging this. Very many points were taken. Again, he turned to Palkhiwala to argue this case. He said that there was a solemn assurance given by the government of India to the princely states that you will be given this much of financial package upon joining the Indian Union. You can't go back, you can't resile from the promised assurance that you had given. The argument was upheld by the Supreme Court. All these three cases against the government were argued by Nani Palkhiwala. But his crowning glory came when 13 judges of the Supreme Court in that famous case, Keshavananda Bharati versus Union of India, again, this case also revolved around, this is again arising out of land reforms legislation, this time emanating from Kerala. Issue was whether under Article 368 of the Constitution of India, the Parliament has the power to amend the entire Constitution, replace the entire Constitution and bring in a new Constitution. That was the question. 13 judges, there was a tie, 6:6. 6 said that, yes, we don't see any limitation, implied or explicit in Article 368 putting an embargo on the power of the Parliament to amend the Constitution. 6 said, no, we must read into it. It was the opinion of Justice H.R. Khanna which tilted the balance. The majority held that the very meaning of the word amend postulates that while you may bring in new, you may alter the original should remain. The structure of the original should remain. That's how they upheld the doctrine of basic structure. They said there are certain basic features of our Constitution which cannot be amended under Article 368. That is a separate chapter, how the basic structure doctrine comes in India. It started in Pakistan. There was a speech by a German scholar in Banaras Hindu University. Earlier also this point was argued in Goloknath. That's a different chapter. We will not go through. This case was argued by Palkhiwala for the petitioner. Now, Mr. Andhya Rujina, he passed away recently, not recently, quite a few years back. He was a senior counsel in the Supreme Court, earlier Advocate General of Maharashtra. He has written a book about this case. And he has titled this, the name of the book is Keshavananda Bharati Case, The Untold Story of Struggle for Supremacy by Supreme Court and Parliament. According to him, though this was cast as a legal issue, it was basically a struggle for supremacy between Parliament and the Supreme Court. And finally, this judgment tilted the balance in favor of the Supreme Court, in favor of the judiciary. The final word will be of the Supreme Court. That's how the system is. That's how the Constitution is. He had argued for the state of Kerala along with his illustrious senior H.M. Sirvai. Again, those who are students of constitutional law would have heard about the name of Mr. Sirvai. Sirvai's Constitution of India, it is very, very important. One should go through it. In this book, he gives an interesting ringside view of what was going on in the Supreme Court during those days. And he also writes about there was an attempt to review this judgment. He says there was no application for review. No one had either in writing or orally made a prayer for review of Keshavananda Bharati. But all of a sudden, the bench constituted, the previous night it was declared that, it was notified that there is a review of Keshavananda Bharati, and then the bench would hear. A 13-judge bench was constituted. That was November 10, 1975, 50 years ago. And in this book, he has given a vivid description of how Palkiwala rose that November afternoone. It was a post-lunch hearing in the Supreme Court, and how he argued. He argued that no case was made out to review. No one had filed any application to review Keshavananda. And in no case, Supreme Court or any High Court had said that because of application of this doctrine, there are difficulties in implementation of the Constitution. No one had said anything. But it was his powerful argument about the unbridled power of the executive in the event the doctrine of basic structure was removed, that impacted the bench. So much so that on the very next day, the review bench was dissolved. See, it is very difficult to get appreciation from your colleagues. As lawyers certainly will acknowledge this fact, it's very difficult, or even for a judge, to get an appreciation from your colleague. They are very, very highly skeptical most of the time. But in this book, Andhya Rujuna, who was not only colleague of Palkiwala, but who had appeared for the other side, he writes in his book that that afternoon, Palkiwala argued with great force and eloquence, holding the court and those present spellbound. Though he was at all times a master orator and a skillful advocate, his arguments on that afternoon were something which those present could never forget. He writes, Justice Khanna was also part of the review bench. Khanna has written an autobiography called Neither Roses Nor Thorns. M.C. Chagla, the first Indian Chief Justice of Bombay High Court, who was there 10 years, he was the Chief Justice. His autobiography he has named Roses in December. Khanna writes about neither roses nor thorns. Khanna says that he was witness to Palkiwala's arguments that afternoon, and that the height of eloquence reached by Palkiwala that afternoon was something which would never be surpassed in the annals of the Supreme Court. This is from a judge hearing the matter. Justice Khanna is reported to have said that many judges, High Court judges, tribunal judges, would take at least a week's time to come out of the spell Palkiwala used to weave around them through the power of his words and his advocacy. Such was the power of advocacy. And just come to think about it, he could not even speak a single sentence in his childhood. This is the power of hard work and perseverance. But I would say the biggest compliment came, and he really became a legend, when the then Prime Minister turned to him. The then Prime Minister had suffered an election petition, an order from the High Court of Allahabad. Her election was set aside on an election petition filed by her political adversary. Raj Narayan had filed the election petition, That's another matter that if you look into the allegations, in today's context, I do not think whether they would constitute electoral corruption or not at all. But nonetheless, at that point of time, Justice Sinha of Allahabad High Court declared the election of the Prime Minister void by allowing the election petition. The Prime Minister had her own team of legal advisors. She did not go to them. She went to Palkiwala. Her legal adversary for all these years, who had fought all her decisions against her in the Supreme Court, he went to her to defend her. Palkiwala prepared the SLP. On the next day, it was a vacation court. Vacation judge was Justice Krishna Iyer. Palkiwala was assisted by Fali Nariman, and they got an interim stay. That's another matter. But point is, the acknowledgement from your colleagues, the acknowledgement from your adversaries, this is something only legends can have. And Palkiwala was indeed a legend. So as students of law, we should all remember all those great men and women who have shaped our judicial destiny. And certainly, Palkiwala was one of them. There are many others. I would, as and when, and if I come here, we will certainly discuss about the other great men and women who have contributed immensely to the growth of the institution. Friends, the study of law today is vastly different, has become vastly different from what it was when we had studied law. I remember I did not do quite well in graduation. In fact, at one point of time, I thought of joining the Film Institute at Pune. My parents were scandalized. So they rushed to Delhi. They said, "You please come back. You study law here only. We are here. I have told the professors. They will take care of you." So this is how I studied law. And those days, they were evening classes. And there used to be a saying that jar nai goti, he kore ukaloti. If you don't have any other option, then you turn to law. That was in the late 80s. Things have changed considerably since then. Maybe Professor Madhava Menon, with his first National Law University in Bangalore, has started the trend. Today, if you look at the CLAT, the mark sheets, you will be surprised. Today, law is the first preference of many. They are not interested in medicine or engineering. As it is, engineering has almost reached a plateau. So people are turning to law. In law, you have got many opportunities. Litigation is certainly one of the options available to you. You can join the academia also. We have so many law universities today all over. But that again is a problem. We have 28, I think, national law universities. In addition, we have so many traditional universities and law colleges. Mumbai alone has 78 law colleges. Just come to think about it. Pune has got 35. Bangalore has got 48. You need law teachers to teach law. So academia is a very, it's a very profitable option available for law graduates. You can also join the judiciary. Earlier, till very recently, no experience was required. If you could crack the examination, you could join as the JMFC first class or the civil judge junior division. Of course, now the recent judgment has come. Supreme Court has put in 3 years of practice. Some of you would like to join the corporates also. But friends, if you ask me which one should I join, I have no hesitation in my mind. There is no profession like the legal profession, litigation. And for a successful lawyer, sky is the limit. But you must all remember, legal profession is not 2020 cricket. Nowadays we are speaking in cricketing terminology. It is not 2020 cricket. We have seen how the life of Palkiwala, how he has struggled, how he has strived hard. Law is not even one-day cricket. You must have the technique and the tenacity to play a long innings like a test match cricket. That's law. It's certainly not a path strewn with roses. But that should not deter us. It is not rocket science. Everything is there in the book. If you study hard, if you persevere, if there is sincerity, there is dedication, there is no reason why you will not be successful in law. It has got its own niceties. As lawyers, you are not the spokesperson of your client. You are not only the spokesperson of your client. You are an officer of the court. And as an officer of the court, you are a highly respected person. You have got a standing in society. Shakespeare is reported to have said about, he had some legal issues, some land issues, so he had to go to the lawyers and the bar in England. So he said about the legal profession, he said, strive mightily, but eat and drink as friends do in law. That is the beauty of the legal profession. Inside the courtroom, you will not yield an inch. You will strive mightily for your clients. But the moment you step out of the court hall, your friends and colleagues, you forget that you were adversary just a couple of moments ago. That is the beauty of the legal profession. The bar, the body of lawyers collectively called the bar, is a powerful social instrument reflecting the social milieu of the times. People from diverse background come and meet together where you develop yourself. Friends, I spoke about Palkiwala. The same chamber, another giant was Fali Nariman, often referred to as the conscience of the Indian bar. He was known as the conscience keeper of the Indian bar. He has written many books. One of the books that he has written is called Before Memory Fades. According to me, it's a must-read book for all of you. He has given details, what to do, what not to do, as you traverse to the rough and tumble of the legal profession. So friends, as you will enter the profession, it is extremely important that you should get acquainted with the procedural law as well as the substantive law. Law, as you know, are procedural law, substantive law. It is essential for a legal practitioner to be sound both in procedural law as well as substantive law before one moves into the high courts. Please don't chase glamour. I hear many of the young lawyers saying, I will do intellectual property rights, I will do IBC, I will do competition law. It's okay. But our traditional litigation still covers about 90% of the litigation space in India. It is where you learn your law. The specific relief act, the law relating to declaratory rights, reliefs, injunction, so on and so forth. This is how you will develop your legal acumen. There's no point chasing a glamorous subject, when you hardly have any litigation in that sphere. In my 20 years of practice, I did only one IPR case in Guwahati. So therefore, don't chase this. There's no point chasing. We have enough civil and criminal cases, as well as on the constitutional side, many cases where you can devote. There's enough space. Now, going back to that one last time, I will go back to the interview. She asked me, "Sir, do you have any message?" I said, "I don't have any. I can't advise these seniors. What should I say? But certainly, I can have a word for my young friends." And I said that there is space for everybody in the legal profession. Don't be unduly worried that there are already so many thousands of lawyers there. Where is the place for me? No, there is enough space under the sun for a new entrant in the legal profession. And you must be able to succeed on the strength of your merit, hard work and perseverance, and not at the cost of others. Law is a teamwork. Basically, it's a teamwork, though there is enough space for individual brilliance, but it is basically a teamwork. So please concentrate on this, and I have no doubt that you will be successful in whichever way, whichever avocation you take up post your LLB degree. I'm sure you are good students and you will be successful in your future life. Many of you may become successful senior advocates, like the senior advocates who are standing here, or like to become an advocate general, like who is here. Some of you may like to become, or may become, a judge of the Guwahati High Court, as Mr. Bhattakur is here. And I would be very happy if some one of you go on to become the Chief Justice of Telangana High Court. I was a Chief Justice there. So friends, please try to search. There is a Palkiwala within each one of us. There is a Nariman within each one of us. It's only how we look at it, and we have the determination to succeed. My best wishes to all of you. Thank you very much, and God bless.